Good evening and welcome to our last session. My name is Philippa Webb. I teach public international law here at King's College London. Our speaker for this session is Professor Eric Posner, the Kirkland & Ellis Distinguished Service Professor of Law and Arthur and Esther Kane Research Chair at the University of Chicago Law School. His book, which has already been referenced today, is The Twilight of Human Rights Law, without a question mark. For this session, we have added a question mark. It was published in 2014, and needless to say, it has caused a sensation. A piece in The Guardian based on the book has generated 8,500 shares and hundreds of comments. His book has inspired other scholarly work engaging with it and intense political debate. His skepticism about the human rights treaty regime forces us to re-examine our definitions, our assumptions, and our methods of analysis. It is a jolt to our complacency or comfort about how we promote and protect the well-being of people. Now, we've already had speakers engage today with his ideas in relation to the right to health and to minimum core obligations. We're lucky to have three eminent commentators to take that debate further this evening. Baroness Onora O'Neill, Emeritus Professor of Philosophy at the University of Cambridge. Professor Michael Ignatieff, Rector and President of the Central European University in Budapest, and Professor Guglielmo Verdirame, Professor of International Law at King's in the Department of War Studies and the Law School. So Professor Posner will speak for 30 minutes and then we'll have 10 minutes per commentator. Thank you.
Thanks very much, and thank you, John, for inviting me and putting together this terrific conference. I've really enjoyed it. I've learned a great deal, which has already caused me to rethink some of my ideas, and I hope to receive more comments. I'm also honored by this incredibly eminent panel that you've put together. But let me jump right into my talk today, and I'm not just going to regurgitate what's in the book. I want to talk about the role of human rights in development, which is the theme of this conference, of course. And I got interested in this a couple years ago. I was invited to a World Bank conference, and it was about other things, but I became interested in this criticism of the World Bank for failing to incorporate human rights law directly into its draft environmental and social framework. And a UN Special Rapporteur on Extreme Poverty and Human Rights sent a letter to the World Bank in 2014 complaining about this omission. And Human Rights Watch has also repeatedly criticized the World Bank for failing to take human rights law seriously, as they put it. So this quote here, Human Rights Watch is disappointed that the primary reference to human rights in the draft framework is in the non-binding vision statement. To suggest that human rights are merely visionary suggests that the World Bank views human rights as non-binding, undermines the international human rights framework, and does not remedy the long-standing problem that the bank does not analyze and address potential adverse human rights impact of its activities. Human Rights Watch sent another letter to this effect quite recently. Now, any discussion of human rights and development has to start with Amartya Sen. He was here today, and he wrote this famous book, Development is Freedom. You all know about this, in 1999, and he was developing ideas of his from earlier than that, of course. And the question that's raised by Human Rights Watch and the World Bank is, what does it mean to ask development policy to respect human rights? And Sen is famous for criticizing, among other things, for criticizing the kind of traditional development community for focusing on GDP per capita or just economic growth. And he made a powerful argument that that should not be the focus or the sole focus of development work. Now, Sen, among economists, is also known for his work in welfare economics, and he had earlier criticized the standard economic framework that had been inherited by the development economists, which is based on maximizing preferences of people or subjective well-being. And he pointed out that that's not a very satisfactory way about thinking about the goals of development or of policy generally. And he said that development policy should advance freedom. And what does that mean? Well, he wasn't entirely clear about what that meant. At a minimum, it meant something different from maximizing a social welfare function of the sort that economists typically use. And he said this was both a normative aim, and he also made a kind of an empirical argument that if you do advance freedom, that will also promote economic growth, which, as he said today, he thinks is also important. But what is freedom? As we've had an extensive discussion about, he focused on capabilities. And I think the way philosophers have cashed this out over the years is that he is a consequentialist, but he has a more objective notion of well-being than other economists do. And so what he's saying effectively is development policy should promote the well-being of people, which includes both, their subjective preferences to the extent that they are at least informed, and also sort of objective things like health and education. Now the question then is, how do you operationalize this suggestion? And there have been two approaches, and we've been talking about them today. One is to use a metric, and the other is to tell development agencies to respect human rights law. So Kiko's work and Sabina's work is more connected with the first approach, whereas I think the human rights community takes more of the second approach. And we've seen the divide, I think, to some extent today. Now, one of the most famous metrics that was suggested was the UN Development Index, which basically just added to GDP per capita education outcomes and health outcomes. This was, I guess, an early, a much less sophisticated version of what Sabina is doing now. And I'm not going to criticize that. I just want to point out that the GDP per capita is actually highly correlated with the Human Development Index. And the reason is that countries which tend to have high GDP per capita also tend to have high health outcomes and high education outcomes. So if you take this approach, development economists were probably not making a serious error by focusing on GDP per capita. And while Sen, sort of puts that approach on a more sophisticated normative flooring, it probably doesn't make much difference. Okay. Or at least that's what I thought until Sabina gave her talk. Maybe it does make a difference. All right. But again, it's not my, this is not my focus. I just wanted to put this up as one way of trying to operationalize this idea of Sen, that we don't want to just maximize, subjective well-being. We care about objective outcomes as well. My focus is human rights, of course, and the question I want to ask is, what does Human Rights Watch mean? What do they want the World Bank to do concretely? There are some legal points here, of course. The human rights law, most people would say, doesn't apply to a non-government institution. But, you can make arguments back and forth. But when we talk about, for example, a government complying with human rights law, we know what that means. It's less clear what that would mean for a development agency. Now, my focus is on the law. I just want to back up a little bit and talk about the language. So human rights, you guys know, it's a very complicated concept, and it's a philosophical concept, and it's a term that people use rhetorically and often sloppily or in different ways. This Google Ngram, I think, is kind of fascinating because it shows how this term has come to dominate public debate and international debate since World War II, and especially accelerating in the 1970s and 1980s. I'm not going to focus on the philosophical arguments at all. I mean, we may have to talk about them. I'm just going to talk about the law. And I'm going to go through the next few slides quickly because this audience, will be familiar with it. But the law is based on a series of treaties that were negotiated starting after World War II and started going into force in the 1960s, 70s, 80s, 90s. And one of the most striking things about this treaty regime is how widespread ratification is. And this chart shows on the bottom the year And the vertical axis shows the cumulative number of ratifying countries. So as you can see, as everyone knows, today, at least for the sort of core human rights treaties, 5 or 6, however you count them, most countries have ratified them. Not just most, the vast majority of countries have ratified all of them. And what I find interesting about this ratification pattern is that the two probably most important treaties, the ICSCR and the ICCPR, they were ratified kind of gradually, over a long period of time, giving one the impression that states were thinking seriously about does it make sense for us to ratify these treaties or not. The more recent treaties are ratified very quickly, and the one that's not on here, the Disabilities Treaty, most countries ratified it within a few years. Well, what are the human rights that are embodied in these treaties? There are a lot of human rights. These two slides show a small fraction. You can count them, of course, in lots of different ways. There are hundreds and hundreds of rights, and people who don't know much about human rights might be forgiven for thinking that human rights mean core interests, that they protect people's core interests. That's just not true. The treaty regime basically covers every aspect of policy, anything a government could possibly do. There's some, trivial things, but basically everything, either directly or arguably, implicates the human rights treaty regime. And not only that, as we've talked about, there are no sort of clear consensual principles for balancing these rights, for prioritizing them, for telling countries how to allocate resources among these rights. Of course, there are a number of human rights institutions. Some of them are formally created by the treaties. There are also NGOs, they're national institutions. The key thing about these institutions is that none of them really has much power. A few of them have some formal legal power. None of them really has power to make an international binding interpretation. This, of course, is deliberate. And they're also, for the most part, starved of funds and other resources and frequently undermined by governments. Now, the reason I mention this is that you could say the same thing that I just said about the treaty regime, about national constitutions. Even a relatively short national constitution like the US Constitution has dozens and dozens of rights, raising all kinds of questions about interpretation and trade-offs and all the rest. But advanced countries have national institutions that are generally respected, that can make authoritative interpretations of these rights, to talk about what sorts of trade-offs can be made by the government. There is nothing comparable at the international level to bring order to this incredible profusion of legal rights. Okay, so has the treaty regime worked? So I first started thinking about this quite a while ago, about 15 years ago, when there was, well, if you go back to the late 90s, there was a lot more enthusiasm, I think, about human rights treaties, or optimism might be a better word, than there is today. Now, you can approach this question in many, many ways. Some earlier speakers have spoken about some ways of thinking about measuring and so forth. I just want to give a few anecdotal examples. I don't really like anecdotes, but I'm going to do it anyway, and then I'm going to talk about some data. If you're thinking about the last 10 years have been bad for political rights, political and civil rights. They haven't been bad, by the way, for social and economic rights. And so literacy, outcomes for women, for children, they've been going up pretty steadily for decades. But there's been some retrogression in political rights. Russia, of course, is a big one. In the 90s, it was possible to think that Russia would be some kind of democracy. China has become more authoritarian recently. But even more surprising are countries in Europe. Poland and Hungary have gradually moved rightward, or in a more authoritarian direction, in a way it's not always violating a specific human right, but certainly in tension with their human rights commitments. Turkey is another kind of a shock. It seemed like it was very strongly moving in the direction of democracy for many years. Now, of course, there are these crackdowns on the press and on political opposition. And there are other examples as well. El Salvador, Ethiopia, the Arab Spring is a good example. When it starts, people say, finally, human rights are moving into this area of the world. It collapses with what I think the possible exception of, is it Tunisia? Now, of course, the United States, people are worried about Trump being elected, and maybe they've forgotten about the torture and the detention that just goes back 15 years, 10, 15 years. The use of drones to engage in targeted killings is at a very minimum in tension with the human rights treaties. There are various legal arguments that have been developed to address that. And of course in Europe, which I think plausibly is really the core of the modern human rights regime, there's certainly this kind of nationalist backlash in this country and other countries, which makes one nervous about the future. Now, the reason why I don't like putting anecdotes is that there are also other countries where things are going in a better direction. Nigeria, for example. So I'm going to talk about data now. Now, it's very, very, very hard to measure compliance with human rights treaties, but political scientists and some law professors over the last 20 years have been trying to do this. And I'm giving you some just very crude results. I can talk, if you like, in more detail about them. But this graph, for example, the unbroken line shows the number of countries that have ratified the Convention Against Torture. So as you can see, there's this steady increase over 20 or 30 years. The broken line is a measure of how frequently torture occurs in countries. And that's less torture is a higher number. So what the broken line shows is that the amount of torture has increased, or I think probably more realistically, it just hasn't changed very much over this period, even though countries have ratified this treaty in great numbers. Now you can look at it a little bit more rigorously than that. Let me just draw your attention to the graph in the top left-hand corner. And what this graph tries to do is measure how much ratification of a human rights treaty affects the relevant outcomes in a particular state. So on that graph, 0 is the year in which any particular state has ratified, in that case, the ICCPR. And the positive numbers that come after the 0 are the years afterwards, and the negative number are the years before. And if you thought the treaties had some kind of direct impact on the country's, their propensity to engage in torture, I have extrajudicial killings, freedom of speech, freedom of religion, independence of judiciary, all of these things implicated by the ICCPR. If you expected the ICCPR to have an impact, you would think the lines would be upward sloping, or even a kind of a step function, just depending on how important you think the treaty is, but they're basically flat. Okay. And there are different treaties you can look at and different ways you can measure this. I mentioned to you before that economic and social rights and women's rights and outcomes for children, they've gradually increased over this period, but there's no correlation between when a country ratifies a treaty and the particular outcome in that country. So things are getting better, and maybe because things are getting better, countries are ratifying these treaties, or maybe they're just ratifying the treaties because there's international pressure to do it. But meanwhile, they're basically implementing like reasonable policy. Something like that is probably what's going on. So when I say states don't comply, I don't mean that they do the opposite. It's just that there's no real evidence. I should, by the way, say there is some controversy over this. Some political scientists have found some effects, but they tend to be small. But as an overall assessment, the treaties haven't had an effect, or have had a very, very small effect on human rights outcomes. So why? Why is that the case? And there are lots of possible explanations, and there's probably an element of truth in all of these explanations. One is that these rights are very ambiguous, so they don't always tell a country to do anything in particular. I'll give an example in the next slide. Another is the proliferation of rights. And this is something that I harp on over and over and argue with people like John about. Countries have limited resources. They just do. You know, there's only so much money they can raise by taxes and selling assets and so forth. These rights require them to spend their resources. And this, of course, is as true with political rights as it is for social economic rights. If you want to wipe out torture, it's not just a matter of rescinding an order to torture people. It is, as was explained earlier, it's a matter of, you know, firing police, monitoring them, investigating them, setting up judicial bodies, probably paying them more, giving them training. And this could be over a vast area, remote areas, incredibly expensive. And so the more things that a country is told to do with its limited resources, the more difficult, I mean, even acting in good faith, the harder it will be for the country to actually do that in a predictable way. It'll say, okay, you want me to reduce torture, but you also want me to build medical clinics and build schools and highways, and, you know, we're doing the best we can, but you're not going to see any particular impact when they're given so many different directives. Another set of explanations has to do with motives. So frequently there are accusations of hypocrisy. I actually don't think that's a huge part of it. At least I think the developed world tends to be hypocritical. The rich countries, you know, they say they want poor countries to comply with human rights, and they probably really mean it, but they're not going to put much in the way of resources. A weakness of will might be a more of an explanation, or something like political inconsistency. It seems like a good idea today. You know, next year when it's time to comply, the resources are not there. There's no political support. And of course, there's always the necessity of making tactical compromises. It is simply not practical for the West to isolate China or Russia. It just can't. And I think that's widely understood. I think what's less widely understood is that's true for lots of little countries as well. Even little, weak countries that are little and seem weak by global standards are actually incredibly important, and you can't really isolate them without potentially causing more harm. And then another set has to do with practicality. So even when Western countries are really trying to get poorer countries to improve human rights outcomes, there are all kinds of difficulties, and these difficulties are very familiar from the development literature. So the development literature is all about, you know, decades and decades of building power plants that are then never used, and trying to, you know, or the old, something of a cliche is giving people malaria nets, and then they cut them up into fish hooks, and poison the water. So there are all these, you know, problems with development projects that have to do with the complexity of the cultures that we in the West are trying to help. We try to help them, but we don't try to really understand them before helping them. And one of the things I really like about development economics literature is that it acknowledges this. And the latest wave of work are these randomized experiments, where they finally say, we don't actually know whether malaria nets will help people. I mean, we think they will, but we don't actually know it. So let's try an experiment. We'll give them to this village and not to that village, and we'll come back in 6 months and see what's happened. And that way you can learn things. Now, of course, the knowledge that's gained is incredibly incremental, and it's not really very exciting. It's really hard work to help people in this way, but I do think it's valuable. This is the example of ambiguity. You know, the ICCPR Article 19 says everyone shall have the right to freedom of expression, except there can be restrictions to respect the rights or reputations of others, for the protection of national security, public order, public health, or morals, which is pretty much all the reasons why a government would ever want to restrict a human right. Now, of course, it's true that over time people have come in and tried to interpret this article more narrowly to give it some bite, but not everybody accepts those interpretations. There is no authoritative interpreter to narrow it down. Now, okay, going back now to development. So part of what I'm suggesting here is that resources that are, if you think of countries as especially the wealthier Western governments as having a pool of money that they're willing to spend to help people in foreign countries, and they do. It's not a very big pool, but they have it. The question is, should they focus it on human rights enforcement, or should they focus it on development? And I want to argue they should focus it on development. And when they focus it on development, they shouldn't try to do a kind of human rights-based development, at least in this sense. I'm putting aside the metric approach, just because of all of the ambiguities and disagreements about what these human rights mean. On the other hand, there's another new area of development economics, which creates grounds for pessimism, even more pessimism. This time pessimism about development, but it can be applied as well to human rights. And the pessimism has to do with the fact that there are very strong correlations between what countries are like 200 years ago, 500 years ago, 1,000 years ago, and how wealthy they are. So things like latitude, climate, this example shows latitude, patterns of colonization, whether there was a slave trade or not in a particular country, when an area first developed agriculture. All these sorts of things that occurred centuries ago go a long way to explaining the distribution of GDP per capita today. And there's good reason to think that these things also explain the distribution of human rights outcome as well, including just inertia. It's very clear that countries with better human rights outcomes today had better human rights outcomes 50 years ago, 100 years ago, 200 years ago. So one additional source of pessimism on top of all of the other sources of pessimism is that it does seem that economic growth and human rights outcomes are more influenced by historical factors than by policy choices made today, including the policy choice to advance human rights by negotiating treaties and ratifying them. One of the reasons why these treaties probably don't have much effect is that they're so ambitious. They're not like ordinary treaties that adjust borders or reduce tariffs. They try to change practices that are deeply rooted in the culture and political institutions that reflect social cleavages that go back decades or centuries. And this is a problem both for development economics and human rights law. The development economists have recognized this problem. I don't think the human rights community really has. I want to leave you with two grounds for optimism, both of which will probably irritate you a great deal. The first is, the fact is that there is a correlation between GDP per capita and human rights, and that outcomes have been getting better, and the most likely explanation for why outcomes have been getting better is something like global openness. Trade, investment, migration. Now, I totally agree with the critics of neoliberalism, the people who say they went too far. The Washington Consensus was just this kind of rigid blueprint that made no sense, and that it caused a lot of harm. But the fact is that if you want to advance human rights, probably the best way to do it, at least if you believe the data, is just to encourage 1990s style with some moderation, globalization. Okay. More trade, more wealth. Why is more wealth correlated with human rights? Well, it isn't always, of course, but the fact is people the people want them, right? People want good health, they want education, they want shelter. So as a country becomes wealthier, it's both the case that individuals have the wealth to pay it, and the government can collect more taxes and use the taxes to build clinics and schools and so forth. Okay. Last source of optimism, then I'll stop. So this is a graph produced by Glenn Weil, who's an economist who I write with a lot. And what this graph shows on the vertical axis is a measure of equality within a country. And on the x-axis, on the horizontal axis, it's a measure of how much the country reduces global inequality, controlling for the size of the country. So in the upper left-hand corner, you've got your admirable European countries. So people always say Sweden. Sweden has a generous welfare state. Spread out toward the right bottom-hand corner, you have the Gulf countries, that everybody hates the Gulf countries. Okay. But the Gulf countries do more for global poverty than the European countries do. Why is this? So the generous social welfare program in Sweden redistributes wealth from, by global standards, extremely wealthy people to very wealthy people. Whereas Qatar, for example, and Kuwait they don't like, it's not like they're not trying to do anybody any favors, but they have these migration programs. So 85% of Qatar's population are foreign workers. They come from places like Nepal and South India, where they might make $500 or $1,000 a year, and they're paid $5,000 or $10,000 a year in these places. So the effect on their income is massive, as a result of which a place like Nepal, 32% of GDP consists of remittances. So there's this very big redistribution of wealth from the Gulf states to other countries in a way that really seems to benefit people, and in a manner that the human rights regime and maybe even development policy has failed. So with that, thanks very much.
Eric, that was very stimulating, and I'm not going to say anything about the development economics side of what you said, but I will make some comments of a rather historical sort today about how we got to where we are with human rights. As everyone here knows, human rights, that phrase literally, dates back to 1948 and the preparatory work, and I think it's, however, very interesting to go back a generation from there and wonder why it happened. Suggestion. It was not an innovation to think that there were universal ethical standards. That had been the common coin of the great religions and the common currency of European thought for generations. But the fundamental notion was that of duty, not rights. Some duties, but only some, had correlative rights. Other duties, they were often called imperfect, not meaning substandard, but incomplete duties, did not have counterpart right holders. Catastrophe was, I believe, the First World War, during which one duty, and a very particular duty at that, was inflated, became wildly popular very briefly, and when it collapsed, took duty down with it. So if you want to think about the role of patriotic duty in the early months of World War II, I believe you've got your finger quite near the origins of human rights. What then happened was that people between the wars were very reluctant to talk about duty, particularly patriotic duty. Many of you will know the novelist E.M. Foster wrote, "If I had to choose between betraying my country and betraying my friend, I hope to God I'd have the guts to betray my country." Nobody could have said that in Europe in 1914 or indeed before then. But I'm afraid my discipline, the philosophers, have a lot to answer for in what happened next. We have all heard of logical positivism. We all know that that involved a claim that normative claims, ethics, political philosophy, also aesthetics, also, by the way, metaphysics, were literally meaningless and to be wiped off the intellectual map. In short, ethics was dead. Maybe that would have been seen as a little provincial aberration because the arguments were rejected very quickly. They were very inadequate. But owing to World War II, there was a tremendous spreading of the proponents of logical positivism across the universities of Europe and North America and also Latin America. Pretty catastrophic, you may say, but what the real catastrophe was that putting moral reasoning into the intellectual dustbin proved a very bad idea, and we see that in the rise of fascist and communist states in and beyond Europe. What to do? Well, you can see the problem that the framers of the Universal Declaration faced. The problem was that saying, oh, we must get back to duty was just a no-no at the time. Rights provided a weak, limited reinstatement of ethical standards, moral standards, if you will. They looked in their original format aspirational, or as people said, manifesto rights. They ditched all discussion of imperfect duties, leaving virtue ethics to romp off in another direction. They also ditched duties to self. Rights was the new vocabulary. And I think it's important to realize the universal scope is traditional, but the narrowness of focus is new. That narrowness of focus is something that people continually try to expand, as Eric has suggested to us, by adding to the tally of rights. More rights is a slogan I often hear said. I wonder whether the people who say it know what it is to take a right seriously. No right can exist unless somebody carries the counterpart duties. I'll finish with 2 comments on states. What was also less clear initially was that rights would be peculiarly linked to states. Universal Declaration, as you know, is in a great muddle. It talks about states and peoples and nations and countries with fine disregard for the distinctions that are basic to politics and political philosophy. However, states won out, particularly with the 2 covenants of the 1960s ratified in the 80s, and you can see all that business that Eric's just illustrated getting going then. Great, one might say. They're getting down to business. Put the duties where the power is, and the power is with the state's party. Problem, that is no longer so clearly true. Globalization has weakened some of the powers of many of the state's party, leaving on the whole the state's party that care rather less about human rights, able to do as they will, and others as they can. So I think we've really got a serious rethink coming. There's some very serious standards that are among the human rights standards. We don't honor them by inflating them and letting them seem enormous while actually undermining them. Thank you.
I've been a human rights teacher for 15 years at the Kennedy School and other places, and I like the provocation of the book, and I want to tell you what I really liked about the provocation of the book, because I hope students will find it useful. One thing Professor Posner is saying is making us focus on rule naivete, which is a phrase he uses in the book. When I teach it, my equivalent word is legal fetishism. The passing, the preparation, the drafting, and the passing of a treaty has no necessary correlation to the elimination of an abuse. And to get it even sharper, the drafting, preparation, and ratification of a convention is sometimes an alternative to doing anything about the abuse. There's some way in which the legal activity absorbs and diverts from, it allows states to pretend that they've done things that they haven't. So I'm perhaps turning your rule naivete comment slightly, but I see a kinship between rule naivete and fetishism, and it seems to me you've put your finger on something important. I also think you've joined many others, and Baroness O'Neill has joined you in making your criticism of rights inflation. We've systematically blurred the distinction between rights that can be correlated with duties and obligations and cashed out and enforced with aspirations, with noble dreams, and with what the Indian Constitution calls state directives for, public policy. And that confusion is especially devastating in the area of rights and development, because the claim you're making very strongly is that if the rights contribution to development is simply to specify the moral goals which you ought to achieve, but does not specify the interrelationship between rights empowerment and economic results, is not doing much work at all. It's just providing a kind of fetishized legal form for a set of aspirations that are floating separate from a development strategy that actually will get the job done. So those seem to me very strong criticisms and effective ones, and I like them a lot, and it feels like you're having cold water drop down your neck when you read that book. But I teach this stuff, and I think it's good to have cold water drop down the back of your neck. Because one of the problems of human rights is it has a semi kind of religious thing. You know, it's very, I mean, it's, you know, it's a cause. And it's extremely important in academic life that we pour water down the necks of the cause, disagreeable as that is, because that's all we can do, it seems to me. So I'm most of the way there, but then the question becomes, and now I parse your title, because it's the twilight of human rights law. And twilight's a metaphor, and twilight might mean we're going to get darkness, but it also means we might get dawn. There's something in the twilight metaphor which is implying we're going into a long darkness in human rights. You're making a historical presumption about where the future is going. I just think that's unknowable. I just think we don't know. And so the metaphor is doing more work than I think you may want it to do, and maybe you ought to think about that, because the history here is real complicated. Larry Siedentop's in the front row here, a great historian of ideas, and shows you the ways in which the ideas of human rights actually go back so much further before 1948. They go back into ideas of human personhood anchored in religious faith, and stuff that's anchored that deep is not going away. There's no twilight for that stuff. That stuff's going to run and run and run. We don't know what's going to happen. So I'd be wary about the metaphor. And then the phrase is the twilight of human rights law. And here I think you're a law professor, and it's right to focus on human rights as law. But human rights is also a politics. And in some sense, you know, when I teach it, because I'm not a lawyer, I teach it as a politics. That is to say, it's a very particular kind of politics which emerged after the Second World War. That's true. Got a wind in its sails in the 70s. It's a particular politics in the sense that it's a moral politics. It says, first of all, there are no political justifications for the inhuman use of human beings. So it's a politics that disallows any political justification for the misuse of human beings. And therefore it's a post-fascist, post-communist politics in that sense, because precisely fascism and communism said there were some pretty good political reasons to break a lot of eggs to make the glorious omelet of the socialist tomorrow, right? So it's a politics which emerges as an anti-politics, a rejection of the politics of communism and fascism that justified the inhuman use of human beings. And it said the purpose of politics is to vindicate and defend a certain vision of human equality expressed in a legal language of rights. And that politics, which is essentially a moral politics that expressed itself in a juridical language of law, has had a transformative effect on the world since 1945 that somehow has vanished from your book. I mean, vanished in the sense of if you ask what has human rights done since 1945, not much really. If you look at treaty ratification and treaty compliance, the only thing it's done is completed the imperial decolonization of the entire bloody world, actually. I mean, what is the first right in the ICCPR? It's the right of self-determination. That language powered the biggest and most important political and moral change in the history of the world, namely the decolonization of Africa and Asia. Huge. And it changed the consciousness, it changed then the moral consciousness of mankind in such a way that a person who looks like you and a person who looks like me, born if we came to maturity in 1945, before the decolonization revolution, would have thought somewhere deep in our guts that we had a right to rule other people with a different skin color. We just would have, right? By the time the self-determination revolution has completed, and it's not completed in fact until 1989 and the last European land empire crashes down, that was the end of something epochal in humankind, which was the idea that some people were born to rule other people. And human rights was constitutive. It was the language that made that claim. And it anchored itself to revolutionary movements that, pulled the flags down from colonial powers and replaced them with rapacious and extremely nasty elites. I don't want to get romantic about self-determination. It was bloody awful half of the time. But it was powered by human rights as politics. Secondly, human rights was part of the second revolution of our time, which was the democratic revolution. And to the degree that there's a global norm that the voice of the people is the source of political legitimacy, that is, to some extent, not entirely, but to some extent, a human rights idea. So that's the second revolution. And that second revolution is in peril, as you say. I sit there in Hungary, and it is in big trouble in Hungary. But it's not gone. And that was a human rights revolution. The third one, which has transformed this room, was the civil rights revolution. Partly a domestic legal revolution, just taking it in America only. But when they marched to Montgomery, one of the flags they carried was not just the American flag, but the United Nations flag. Why did they do that? Because the leaders of the civil rights revolution in the United States understood it to be a global struggle, and they understood this not to be the cashing out of equal protection under the law, the domestic rights tradition, but also making use of the language of international human rights. And Martin Luther King saw a deep connection between the civil rights struggle and African independence, and all that stuff is part of the story about why you get the Civil Rights Act in 1965. Human rights is part of a subordinate part of what you could call the Civil Rights Revolution. From the Civil Rights Revolution, you then get the Feminist Revolution, you get the Gay Rights Revolution, and that has changed everybody's mind in this room, probably for good. I mean, it's given us a whole bunch of problems. I don't want to be sentimental about it. But those three revolutions, the self-determination revolution, the democratic revolution, and the civil rights revolution, the equality revolution, the individual rights revolution, in all of it, they were social struggles, political struggles, massive struggles in which human rights was a driver language behind these battles. So the human rights that did make a difference was human rights as politics, human rights anchored and driving those political struggles. It had nothing to do with treaties. Everything you say about treaties is right, and it kind of misses the point. And so you don't want to have an account of the twilight of human rights law that somehow puts you in a position as if you weren't present through the second half of the 20th century. I'm being, because I loved the book actually and thought it was really, but I read it and thought, wait, this is my life here. Where's my life in this book? So this is an issue, and this is not really an argument about history, because I think you would acknowledge much of the history I've pushed back in your face. It's really an argument about what is human rights. And I'm saying you can't understand this unless you think about this as a politics that uses moral claims in the law to mount social struggles to emancipate people from colonial subjugation, to emancipate minorities from oppression, and to advance the claims of individuals to justice. Then the question that I think, just to end, where I think you raise some very fundamental issues, is whether human rights still has that capacity to inspire social movements. You've raised fundamental issues about whether it can be of any damn use in development. And you've said, give me a good development economist any day over some human rights fetishist walking around saying what this country needs is a new constitution. I mean, I get that big time. And so that's a question for all of us. Has this thing run out of gas? Is it unable, conceptually, to help people to get development in Namibia, South Africa, West Africa, et cetera, and Asia? Has it run out of gas in that way? And you've perhaps suggested some ways in which it has run out of gas. But my sense here is that when you think about the historical depth of these ideas of human dignity, how deeply they run, how much work there still is to do, and when you think of human rights as a politics, as a moral politics, which expresses itself in law, and self-limits it and says, there's some things to achieve my goals I will not do. That is what defines my politics. Then you've got something that is not seeing twilight. I really do think that we don't know what the hell is going to happen, but it ain't twilight and it ain't darkness. Thank you.
Not sure how far.
I want to...
No,
No, let's just change...
It doesn't reach very far, so...
It's not going to reach
I'm going to change seats.
or I can see.
I'm going to change seats. It's fine.
Is it on?
Yes.
Right. Well, thank you very much to John for organizing it, and to Eric for his book and for his presentation. Like others, I also think that there's a lot of thought-provoking and important and often uncomfortable criticism in Eric's book. And there is much of his arguments that I would agree with. I do agree, like Baroness O'Neill and Professor Ignatieff, that we do have a problem with human rights inflation, with the proliferation of human rights instruments and institutions. And I think it is also fair to reflect on the ways in which human rights may have crowded out other legal and non-legal considerations. In the area in which I work, mainly war, there is a tendency, both in litigation and in academic writing, to say that human rights can replace the law of armed conflict, that we can now regulate armed conflict through human rights treaties. Some people even suggest we can dispense with the Geneva Conventions and just have human rights treaties do the job. Now, these ideas, I think, pose a danger not only to the regulation of armed conflict, but also to human rights. The law of war was developed with the extreme circumstances of wartime in mind, and considerations of feasibility in wartime are very different from what they are in peacetime. And so to preserve the integrity of the law of war as a discrete area is also a way of ensuring that peacetime continues to be regulated according to a different moral logic. And I would also agree to quite a large extent with Eric's concerns about human rights crowding out economic and political argument, especially in the development arena. I think there is a lot of legitimate disagreement to be had on which policies work to promote development and which do not, and a lot of disagreement on what to prioritize. And I think some of these concerns were addressed in the panel on minimum core obligations. And I'm certainly very sympathetic to the criticism that Eric develops of international human rights adjudication and international human rights institutions. These are institutions that are by their nature abstracted from the laws, the experiences, the beliefs, the traditions of a particular society, and so I think they should proceed with great caution. I think their role should be to guard the fences rather than constantly try to push the boundaries. And the development, for example, of the living instrument doctrine of interpretation by the European Court of Human Rights, I think, was a mistake. The ECHR is a treaty-based organ, and it should stick to rules of treaty interpretation when it interprets the convention. It shouldn't try to become a sort of supranational constitutional court. So that's where we agree, and I think it is quite a lot. But there's also a lot of disagreement. And I'll try to highlight 4 areas of disagreement. The first one is that in the book, at least, less so today, it isn't clear to me really what his target is. Is he attacking the moral idea of human rights, the values that human rights seek to protect, or does he have a problem only with the institutions, the legal rules that the moral idea of human rights may have been embodied in? Or is he concerned even more specifically just with the Human Rights Treaty, which is a particular legal form that the moral idea of human rights may have taken, as opposed, for example, to constitutional bills of rights? One could, for example, take the view that health and free expression and due process are all important values, but that international law is simply not the right way of promoting them. Sometimes it seemed to me that his main concern was about the justiciability of these treaty-based rights, which again is, as we heard before, an important problem. Today he's focused mainly on human rights treaties, and his main criticism of human rights treaties, and this is my second point, is that they have failed to improve the well-being of people. Now, John touched on this point in 2 panels ago, so I don't dwell on it, but it does seem to me that judging human rights by the measure of well-being isn't really quite right. Well-being may be one of the purposes that human rights are designed to promote, but by no means the only one. And in some cases, human rights may be antithetical to especially a collective idea of well-being. They may promote other moral ideas. And so I'm not sure that well-being is really the right framework for judging human rights. But then we move to causation, and this is my third area of concern. And here, Eric, together with other political scientists and lawyers in America, argues that human rights treaties have failed to cause any significant change or detectable change in either well-being or the extent to which human rights are concretely enjoyed. Now, putting aside the question of well-being, whether that is really the effect you have to look for, I think it is certainly fair to ask ourselves whether human rights treaties have improved the enjoyment of human rights, which is ultimately what they were designed to promote and protect. But I think the correlation here, and these are points that Professor Ignatieff has already touched on, that there's a problem here with the empirics that seem to me to be really quite crude. The correlations here between human rights treaties and other forms of human rights and human rights politics and a change have to be interrogated far more critically. And if you think about constitutional Bill of Rights, I think we could have a lot of fancy graphs showing that constitutional bills of rights have had no impact in the 1960s or 1970s. There was a surge in constitutional Bill of Rights around the world in the early 60s because of all the newly independent states. They were all protecting every possible right you could think of in their constitution. And yet the enjoyment of political liberty and the rule of law didn't make significant advances in that period, with the important exception of self-determination, which is itself a human right. So these things may take much longer to develop than he seems to assume. And I know that there are starry-eyed international human rights lawyers out there who are saying the wildest things about the transformative effects of human rights treaties, but I think in fairness to them, and I think one should be more charitable to the starry-eyed than the cynic, perhaps, I've never come across the claim that human rights treaties are the sole condition, the sufficient condition for achieving the enjoyment of human rights. I don't think anyone seriously put forward that idea. Some people may have argued that human rights law, rather than just treaties, may be necessary to the enjoyment of human rights. There was quite a lot of debate essentially around that idea in this country when the Human Rights Act was adopted. Common law constitutionalists were saying we don't need this Bill of Rights. We can protect these fundamental ideas of liberty through the common law. We don't need a Bill of Rights. But then history moved in a different direction. I think as far as the role of human rights treaties specifically, the picture is therefore much more complex. We would have to look at the way in which the treaties may have helped keep alive the ideas, the politics, how they may have helped mobilize or non-governmental organizations and societies in different stages of their history. And even if the role of treaties themselves has been marginal, before we sort of throw them away, we have to ask ourselves what would happen to the idea and the politics of human rights if the treaties disappear. And we have to, if we want to have a proper calculus, so to speak, we need to factor that risk in. And again, this is also a point that has been made. We need to think about the long sweep of history. Ideas like the moral equality of human beings and Michael Ignatieff referred to Sir Larry Seedon. These are ideas that have taken centuries to change the consciousness of human beings and societies. And we are only at the beginning of this globalization of a particular moral idea of human rights, and the treaty is just one legal form that this moral idea is taken. But I think, if we in circa 1825 had looked at the US Bill of Rights and said, let's throw it away, there's still slavery, it wouldn't have been a very smart move. It is true that judged by that particular and very important question of slavery, the US Bill of Rights had not achieved very much. It took, 80, 90 years for slavery to be abolished. But it would have been better to keep it rather than do away with it before the abolition of slavery. And I'm sure that if the North Koreans, as everyone hopes, will one day become free again, they shouldn't think, well, shall we have a Bill of Rights? We've had one for 70 years. It hasn't had any change. Let's now start again without any Bill of Rights. That, again, wouldn't be very good, I think, empirical and normative thinking. I think the fourth point, and with this I will conclude, is on this clash between development economics and human rights. And it seems to me to be a false choice, to some extent demonstrated by Eric's own empirical analysis. I mean, if there has been a steady improvement in socioeconomic rights as a result of development, then there seems to be, as far as socioeconomic rights are concerned, a positive correlation between economic development and the enjoyment of socioeconomic rights, rather than this sort of big clash. So I was wondering whether the clash that he's really trying to tackle is one between political liberty and socioeconomic development, but that again is quite a complex area. Amartya Sen would disagree with the view that political liberty and socioeconomic development are inversely correlated. And it certainly doesn't seem to me, and I practice as a barrister in the field of international law, it doesn't seem to me to be the problem that we face today, that states are diverting huge resources into human rights treaty compliance and shutting down schools and hospitals because they are trying to figure out how to comply with these human rights. It's a small part, very tiny, negligible part of what a state does, thinking about how to comply with these human rights treaties and engaging with human rights institutions, flawed though they are, etc. And then I think one final comment, and with this I will conclude on economics, and here I will refer to the other Posner, who sometime towards the, I think it was 2009 or 2010, writing in the New Republic, a beautiful article on the state of economics after the financial crisis, and saying that he had discovered John Maynard Keynes as a result of the financial crisis. He writes, I've come to realize that perhaps economists do not understand the economy that well. Well, if we're still, economists have not yet begun to understand the economy that well, why should we let them handle morality? And with this,
So we've had three interventions, I think, almost as provocative as the original speaker. I'm now going to give Professor Posner a few minutes to respond, and then we'll open up to the audience.
Yes, I'm going to respond very quickly, and I'm not going to do justice to these comments, which were very powerful. And in fact, I'm going to give one response effectively to all three comments, because they all in one way or another make a very similar point. Before that, I just want to quickly respond to Guglielmo's last point. I do think there is definitely a choice. The World Bank, so for example, the World Bank doesn't want to be doesn't want to acknowledge being constrained by human rights because it thinks that it will interfere with its development policy. That's just their view. And I think what they're really worried about is that every time they think about a policy, there's going to be this very long bureaucratic process where a bunch of lawyers go over the plan and try to figure out whether this is consistent with human rights, which would effectively transfer much of the discretion to a bunch of lawyers who don't know much about the particular development problem. And the other example is actually the slide there. So I neglected to mention this, but Qatar, is not, well, you guys know this, is not an exemplar of human rights. They accept all of these migrants almost precisely because they're not going to respect most of their rights. They're segregated, they're kept away from the rest of the population, they don't have any political freedoms. They're constrained in many ways, but they're paid very well. And ultimately, this is a choice between rights and well-being, which I think we have to at least confront. Okay. So there's a reason why law is in the title. The book is about the law. So I don't, and I think as you recognize, I don't deny human rights as a powerful moral ideal. I think when we talk about the American Civil Rights Movement, colonial India, South Africa, the USSR before the dissidents in the USSR before the fall of communism, there are certain common themes. I think there's a lot more that's different than is similar, but there's certain common themes. These things are coming out of different traditions, and people have different goals, and they probably disagree about most things. But some things they agree about, which is that they shouldn't be dominated by this group of people, and human rights provided a powerful rhetoric and inspiration. Although I think in the civil rights movement, the real inspiration was the Bible. Was religious in the United States, but human rights played a role. But the problem is, so I'm not saying that human rights is bad. I'm not saying the Enlightenment was a mistake. I'm not saying that. I like all that stuff. I like all that stuff. But I think what I don't like is the attempt to take the commonality that exists in these different contexts and transform it into a document with a set of rules that everybody is supposed to comply with. That I think was a mistake. And it was a conceptual mistake. I don't think it was a mistake in the sense that it caused a lot of harm. Part of my point is that there's just no evidence that these treaties or the accompanying legal regime did any good. And I think there's an important reason, and this gets to a point that all of you touched on, which is the profusion of rights. The problem is that when you sit down and you try to figure out what South Africa, U.S. Civil Rights Movement, India, and so forth all have in common, you can quickly point to certain important things like political participation and so forth. But you can't stop. You have to keep adding rights. And the reason why you have to keep adding rights, it's not because this is not some kind of conceptual mistake or philosophical mistake or just bad advice from some lawyer. These governments had to add more rights because the logic of governance is such that you have to address everything that the population cares about, and that you cannot put all your resources or most of your resources or political attention or whatever it is into a small number of things like preventing torture or arbitrary detention or giving people medical help or so they had to keep adding additional rights because there are so many things that people care about. And I do think that the way governments act is basically utilitarian by necessity, not utilitarian in a rigorous philosophical sense. I mean, basically what governments do, even mediocre governments, is they look at the population and they try to give people what makes them better off, which also is most of the time what they want, right? And that I do not think can be reduced to a set of rules. And this is legal fetishism. Is that what you called it?
Yeah.
Or what I call rule naivete. Now you need to do so. There's a tension here, and I think you have constitutional systems which do this. But what's really going on in those constitutional systems is that the power to implement these rules in a sensible way, which is really a kind of a welfarist way, is delegated, partially to the courts. That's really what's going on. So they're not, and then the courts can use a sense of the culture and what people really need and politics and all the rest to implement these rules in a sensible way. I do not think that's possible at an international level because I think there's too much divergence between countries and distrust so that you can't create a comparable institution. So I do think human rights played a big role in decolonization and the rise of democracy. I think it's kind of complicated. There are all kinds of ideas that were playing an important role. But I'm just interested in the law. And the law might not interest you, or it might not interest some people. They shouldn't read the book. The book is just about whether the law had an effect. And while Guglielmo is right that you can never really be sure, what I don't like about that response is that that's really a defense of everything. So what I like about the development economists, with some exceptions, they haven't doubled down and said, well, the development projects that seem like they were failures were not actually failures because they sowed the seeds, so that 10, 20, 50, 100 years in the future, there'll be this great flowering of economic development. That is a possible argument to be made. You cannot disprove that empirically. And the same argument can be made about the human rights treaties. There's no way to prove that that's wrong. But at some point, you just have to make this judgment. If the things that they're supposed to be doing are not happening, then they're not working. And rather than try to double down on them, the responsible thing to do is try to figure out what might work better.
Thank you. So now, we've got some hands coming up. I'm going to take about 3 questions and we'll do a couple of rounds. Microphone, this group here.
Thank you so much. I have 2 quick questions. Maybe pursuing this question of whether development and human rights are in some kind of tension. I didn't think that that you suggested in your initial talk that there is a necessary tension, that they can go together, and in fact your graphs show. But I wonder if you can say a little more, maybe all of you, about whether the contingent tensions are important. So one of the things that maybe you alluded to was that it diverts resources, right, from economic development whose short-term impact on respecting human rights is not maybe visible or great, but whose long-term impact we should greatly care about. So that's the first point. And the second point, very quickly, what do you make of arguments such as the one that put forward by Beth Simmons, who precisely links some of the concerns that Michael Ignatieff has raised about the domestic effect of human rights. So in mobilizing for human rights, she says international law, maybe doesn't have great effects in terms of states' immediate compliance, but it mobilizes, it gives people a voice in which to articulate their claims against their governments. It allows international institutions to put pressure and other states to put pressure, so on. Thank you.
Yes, beside you.
Okay. So this question connects to some of the questions that Guglielmo and Professor Ignatieff have already asked. So one is, this is really a request for clarification. So when I think about the claim that human rights law hasn't really improved the well-being of those that were the intended beneficiaries of human rights law, it seems to me that this claim rests on a sort of counterfactual, right? So we see that, for example, the United States have signed up a bunch of treaties, and then we see then there's Guantanamo, there's targeted killing and all that stuff. That doesn't seem to me enough to conclude that the fact that they signed those treaties made a difference. The fact that there is a human rights law makes a difference, because we have to think about what the right counterfactual is, right? So what would have happened if those treaties hadn't been in place? So I was wondering if you could say something more about that, because until I know the counterfactual, I really don't know how to assess the claim that you're making. And there was the second point, which also connects. This is something that Professor Ignatieff said. So when I think about how we assess the value of having human rights law, I'm thinking about the sort of stuff that he's talked about, but also I'm thinking, as of today, even if the US fails to comply with some of the treaties that they've signed, there seems to be at least this idea that we can use the fact that they signed those treaties as a reason to call the US to account for failing to comply with those treaties. And we can put pressure on them for for failing to do so. So that seems a powerful tool, and it's hard to quantify the effects of this tool, but it seems to me a powerful one.
And those behind you, directly behind you.
Thanks. Thank you for the very inspirational talk. I was just a bit wondering at the end what you left us with. So on one hand, at some point you mentioned the proliferation of rights being one of the causes of failure, right? And on the other hand, one of the sources of optimism is that you say wealth has a key function and a key relation to human rights. So my short question then is, could you catch two birds with one stone and solve the human rights project by limiting the international standard to a couple of economic keystone rights like property, contract and labor? Or would that be a wrong conclusion and you rather aim at sort of economic policy in general? Thank you.
Okay.
We'll go down the lines.
Okay. I'm going to give very brief answers just because there's so many questions, but I don't mean to imply that these answers are easy if they're very brief. On the first question from the first person, I think the short-term, long-term distinction is very helpful for understanding what's going on. So the worry is that maybe an overly literal interpretation of human rights treaties will interfere with development projects in the short term, that over the long term should make human rights advocates happy. Now that seems like a problem for the human rights community. They need to make their own judgment about whether these sacrifices are correct. So John, in his discussion of minimum core obligations, actually I found quite surprising his argument that you could, in effect, violate the short-term ones in order to advance the cause over the long term. So if he thinks that, maybe he would take the same view about human rights projects. On Beth Simmons, I think so. She has this hypothesis that human rights treaties help mobilize domestic groups. I think it's a plausible hypothesis. It's not exactly what she tests in her book. Her book, she doesn't have much of a variable for domestic groups, so she has very crude proxies. So we don't, in the end, really know how important that is. The bottom line in her book is she does, by the way, find some evidence of some rights and some treaties having a positive effect. I discussed the book in my book. I think her findings are really very narrow and do not suggest that the treaties have much of an impact. And of course, causation is an enormous problem. As long as these indicators are increasing, you would, if you do your regressions in a very sort of crude way, you're going to get positive results even if they don't have any causal impact. On the role of the counterfactual, the way the regressions, this is on the second question, the way they work is they effectively try to compare a country that ratifies a treaty to a more or less identical country that doesn't ratify the treaty. And if the treaty had an effect, you'd expect a difference in what they do, when in fact there's not. So we don't really even get to the question of how big a difference there was. If there was a difference, we would still have to ask ourselves, is the treaty having the entire effect it's supposed to be having, or just a minimal effect? Well, we can call countries to account for failing to ratify treaties, and this is a constant source of discussion. I mean, this is being done almost continuously, but if in the end they don't actually comply with the treaties, I don't think it's doing much good. I have nothing, by the way, against moral criticism of countries, right? We'll do that anyway, whether they're treaties or no treaties, and that will influence countries. The criticism is the legalism. And then the last argument, well, I think this was what people now, especially in Europe, call the neoliberal agenda of the 1990s. The idea then was, if everybody's just like the U.S., they'll be wealthy like the U.S. and great like the U.S. That was, I think, the sort of implicit idea. I think that was wrong, and that's connected with my criticism of the human rights treaties. It is, in a way, it makes the same mistake, which is to assume that you can reduce what's called good government rather than well-being. Good government to a prescription that can be determined in Washington or Geneva or New York. I don't think I don't think countries can really do that. I think governments can do that, or countries can do that. Governments primarily are responding to the needs and interests of their population. And that's mostly what going to determine what they do. And the human rights treaties reflect that so imperfectly that I think that's ultimately, not in the sense of totally inaccurately, but just in the sense that it doesn't provide any mechanism for making the appropriate balancing and all the rest of, and reflect all the constraints that governments face. So because of that imperfection, I think that's ultimately the reason why countries don't actually pay much attention to what the human rights treaties require.
Just comment this far. I think that I think we're more agreed than you might have thought on worrying about pseudo-legalism, about the idea that a human rights regime is sort of like the law that is internal to a jurisdiction, in that there are well-established ways of revising, of enforcing, of pursuing those who breach the law. And it may be that really Michael has pointed us the right way. We need to think about the politics, but I'm afraid there are an awful lot of people who are thinking about the politics quickly slide over and imagine that it is the legal structures that are the crucial thing rather than the politics. Well, perhaps they aren't.
I think what Baroness O'Neill said is important. I mean, I think that Professor Posner's extremely skeptical, it seems to me, that international human rights law rises to the standard of what law actually is. Because the standard, and it's the right standard, is domestic constitutional law, or the domestic law of states. And I share some of his skepticism about that. That is, whether it actually meets formal definitions of what law is, if you've got no enforcement and no appeals and none of this stuff, and it's severed from enforceable legal structures. But that then, if you then ask the counterfactual, what would have happened had there been no attempt to codify into something called law a set of principles like self-determination, a set of principles like that individual human beings have personality in international law. If you hadn't made that attempt to create this structure, would you have had the politics? That is, would you have had the effects that I think, on balance, have transformed the world? So it's a kind of complicated thing I'm saying here. I actually share your skepticism that this rises to the level of law. I'm happier to teach it as politics, but I'm also aware that part of why it was a powerful politics, and I'm not sure it will be a powerful politics through the 21st century, is that it marched in the clothing of law. It put on the garments of law. And you've asked a very tough question about, let's take the garments off, take a look. Is this really law at all? Or are you just pretending, as it were? And I think that's a powerful criticism. But I think if you look at it as a historian, it's just the case that if you hadn't soldered together a politics, a moral claim, and cast it as a legal claim, I'm not sure a lot of what happened in the 20th century would have happened.
If I can I just want to respond quickly, because that is an important point, and the counterfactual, I think I didn't adequately respond to your question about counterfactual. So this is what I think the counterfactual is. So the dominant international politics was the conflict between the Soviet Union and the United States. And there are two moral paradigms that were held up. U.S., sort of liberal, quote, liberal democracy with some exceptions, and then socialism on the other side. And Europe had this social democracy position. And much of this debate occurred, and as well as decolonization, of course, before any real legalization. And you know Sam Moyn's book also, it wasn't just an issue of legalization. He argues that human rights wasn't really, you know, a big part of what was going on until the late 70s. And so you have that, and then you have, now the 80s are going to be complicated, but I think you have that, and then you have the collapse of the Soviet Union. What happens with the collapse of the Soviet Union? That type of socialism is totally delegitimized, and there's a kind of overreaction, the kind of end of history overreaction, saying that America or Europe or some combination of them got it right. And the international politics would have been, you know, neoliberalism, which is what we got with force. And then that falls apart, okay? I don't think you need law. I don't think you need law at all in that story. You don't need the treaties. What you have are these powerful paradigms. And people were debating in the terms of these sorts of paradigms going back, you know, through all of history about, you know, which kind of political paradigm works best. And I think of the law as, you know, effect rather than cause. An attempt to make these points, these political points, by getting some kind of consensus in some kind of international body, but not having a lot of causal force.
Okay, I'm just going to take two more questions. Up the back.
Thank you, Professor, for writing the book. And sticking to the human rights law, I think it's good that to throw some cold water on human rights lawyer, and in this, I think you're not alone. Before you, probably there were American legal realists and Scandinavian legal realists that simply said, well, human rights simply don't exist. They are a rhetoric, they are sort of a legal magic. The point, however, is that I have the impression that many times, especially in cases in which the enforcement mechanisms are weak, we need that sort of legal magic in a way, and we need to accept the value of rhetoric and irrationality at a certain extent, which is in a way fueling the successful constitutional national mechanisms that we observe. I wanted to know what do you think about it?
And on this side. Just there. Yes.
Thank you. Lady O'Neill, I was very interested in your comments about philosophy and the origins of human rights. I tend to agree with you that human rights have a much older origin. The main author of the United Nations Declaration was Charles Melick, who was the doctoral student of Martin Heidegger, who's not normally seen as a progressive figure. Could you comment on that?
No guilt by association.
I'd like to equal that in brevity. I can't, though. So we need legal magic. I think the problem with that is then we're unprepared for reality when it bursts through the beautiful illusion that we've knitted for ourselves. And of course, we're living through this, right? We're living through this nationalistic, xenophobic backlash in Europe and in the United States. And I think that I don't want to pick on the human rights community. I think it's like the elites in all of these countries were unprepared for this because they believe the magic.
So please join me in thanking our speaker and our commentators for a fantastic